It's now my pleasure to introduce Kylie Moloney from Kylie Moloney Legal, who will be moderating this session for us. So Kylie Moloney is the principal of Kylie Moloney Legal in Maryborough. She is a Law Institute of Victoria accredited specialist in criminal law. She also practices in the areas of child protection and family violence intervention orders. So prior to opening her own legal practice 4 years ago, Kylie was employed by Victoria Legal Aid in their Ballarat and Morwell offices for 9 years. Kylie, her husband and their 2 children live on a few acres with a small menage and enjoy camping. Thank you, Kylie.
So the format of this afternoon's panel discussion will be based around a case study. So we will have the case study will be read out in sections, and then throughout the we'll intersperse with questions which will be put towards our panel members. Now, if I could begin by introducing our panel members so that you all know who we're dealing with. First of all, if I could introduce Amanda Conn, who is down here. She will be reading out the case study to you all as we proceed through. Amanda is volunteer extraordinaire. So during her childhood, she travelled extensively with her father, who served in the Defence Force, and she's lived up in the Territory and studied has studied a diploma in children's services, which led to a career in childcare and social work. And this has led to her having a strong passion for social justice and welfare advocacy within many local groups, including being a co-lead facilitator and participant groups that give women with lived experience a voice. She enjoys also being breakfast club coordinator and school council president at her children's local school. And she's a mum to 3 strong independent children, one of whom has complex allergies, and she continues her advocacy as a mum and carer for children with special needs and disabilities. Then if I could throw to our panel members. I'll start directly beside me and move down. We'll start with Dr Rob Southgate, who is a community lawyer with the Loddon Campaspe Community Legal Centre, specifically in the areas of family violence. Rob, would you like to tell us a little bit about your background? And then we'll move on to the next person.
I guess I came to law late. I was previously a scientist, and that all got a bit dull. You end up turning into a bit of a grant writer. So I went back to study law. So, fortunate to be here. Happy to be on the panel. Looking forward to some questions.
Hi, I'm Tim Mulvany, an old lawyer, 46 years admitted and still practising. And for 38 of those 40 years, I've been an independent children's lawyer. I've recently surrendered because some teenager said to me, "What would an old fart like you know about life?" But I've had the privilege, if that's the word, of being involved in the more extreme and very, very difficult family court cases. I had the honour, and I say that with great pride, but with tragedy, of being appointed the independent children's lawyer on the day that Darcy Freeman was thrown off the bridge, so I had to be the advocate for her surviving brothers. And on the same day, I was appointed independent children's lawyer for 3 children whose father was sentenced for 27 years for murdering the mother's partner. And I dedicate my time here today to Darcy and to her surviving brothers and to those 3 children, but always to all the kids that I had the privilege of advocating for.
Hi, my name's Liz Wright. I'm Acting Program Manager for Anglicare Child and Family Services, and so that role covers Bendigo, Maryborough and Swan Hill. So I oversee Child First and a range of family services programs where family violence is very common among all of the areas that we cover. Thank you.
My name's Michael King. I'm the Regional Coordinating Magistrate for the Loddon Mallee region, and I have the privilege of sitting out in Maryborough Court regularly on circuit. So I, working with the Court Registrar, who's also Senior Registrar who's here today, we jointly ensure that the courts throughout our region run smoothly, and a great deal of our work, unfortunately, is dealing with family violence. Before my appointment to Victoria, I was a magistrate in WA, where I presided in a family violence court for 4 years, and previously as the drug court magistrate in Perth.
My name is Pamela Brown. I'm not a doctor, as it says in the program, and I have to humbly admit that I haven't got a degree as a doctor. I'm just a psychologist, but that's all right. I've had a long and interesting life, and when I started studying psychology 47 years ago, I remember one of the most outstanding facts that they told me was that 90% of people in psychiatric institutions and forensic institutions had been abused as children, and that was rather an outstanding thought. And in that same year, it was my first year at university, my brother's girlfriend, who was the same age I was abducted, raped, and murdered. And so sort of this parallel life of dealing with and understanding people's psychological being as well as experiencing many crises and many traumas in my life. I've had 4 friends murdered over a period of 12 years. So always questioning why, what's going on, how can this be prevented? And I think that's why I have been very involved in trauma psychology for the last 20 years. I've worked with defense, police, and I'm particularly interested in children who are traumatized. And I don't know if you realize, but PTSD wasn't identified until 1985. The acknowledgement that children experience PTSD symptoms wasn't recognized by the psychiatric community until 2013. That's 4 years ago. And yet they have the same symptoms. Their brains are affected by exposure to trauma. It affects how they develop, how their brains develop. It affects their health. And it even affects their lifespan. People who are exposed to trauma as children die 20 years earlier. So it's quite a passion of mine to look at how you help and how you treat children exposed to trauma.
Hello, my name's Cate Moloney. I work at the Centre for Non-Violence in the Client Services program. My role there is Senior Manager of Outreach Services. My practical experience in this area is 15 years at working at the Centre for Non-Violence, where I've provided responses to women and children that have experienced family violence. And over the past 5 years, I've entered into the work of men's behaviour change program. So I'm also a men's behaviour change practitioner within the programs that the Centre for Non-Violence delivers for men who choose to use violence towards family members. Thank you.
And my name is Margaret Singe. I'm a Sergeant at Victoria Police. I'm the Family Violence Advisor for this area. So my role is really oversighting police response to family violence. I've been in the police force for 36 years and in this role for about 6 years.
All right, so we'll move first of all on to Amanda, who will begin with the case study. I'd like to point out that all of the information contained in the case study reflects the experiences of a range of women in this Central Goldfield Shire, but no one individual. No real client names or personal identifying information has been used in this case study.
All right, introducing the family. Fiona and Michael have been married for 10 years. Fiona is 36 years old and works as an administrative assistant at a local primary school. Michael is 38 years old, works for a bank and is a member of the local football club. Fiona and Michael have 2 children, Brodie 9 years old and Georgia 6 years old. The children attend the primary school where Fiona works. Fiona and Michael live on a large rural property on the outskirts of Maryborough. History of family violence. Fiona rarely sees her family since marrying Michael, who does not get along with her parents or allow them to visit. Fiona stopped working, staying home to raise the children and contact with most of her friends. Michael considers himself to be the head of the household. Michael controls all the spending and household finances. Fiona often has to ask for money to purchase petrol and groceries. Other than going to work, Fiona rarely has opportunities to socialise. Fiona suffers from anxiety and lacks confidence in social situations. Michael is well known and respected in the community and has a lot of friends throughout the football club. At home, Michael has a short fuse and gets angry often. He often swears at Fiona and in front of the kids, calling her useless and a terrible mother. Once, during an argument, Michael pushes Fiona. Fiona trips and hits her head on a kitchen cabinet. Another time, Michael punched Fiona, punched a hole in the hallway wall. When Michael has these outbursts, he says that he's just stressed at work and doesn't mean it. He always apologises. Fiona wants to believe Michael when he apologises and says that he won't do it again. Michael is good with the kids, taking them to footy and sport, and Brody, his son, looks up to him. Fiona is becoming more anxious and fearful about people finding out about her home life and puts on a brave face at work, where she is good at her job and appears happy and confident. Fiona is worried about speaking to the police, some whom play football with Michael, and she feels hesitant to contact other local services in case people know her or the kids from the school or know Michael. When Fiona goes back to work full-time, the arguments between her and Michael become more frequent. Fiona tells Michael that he is not pulling his weight at home, and Michael tells Fiona she is undermining him in front of the kids. Michael becomes physically violent towards Fiona, and she spends lots of time covering up bruises on her body. Fiona knows that Michael also checks her phone, and he regularly grills her about her calls and accuses her of having an affair. Attempts to leave and seeking help. Fiona is thinking about leaving, but she's not sure how to go about this. She takes the kids to the library on weekends and uses the library computers to search for houses for rent and support services, but she struggles to find information about local options, particularly for women and children, and wonders how she will manage. Fiona knows that Maryborough District Health Service support's available, but is hesitant to speak to the workers there in case someone recognises her and word gets back to Michael that she's thinking about leaving. Fiona takes the kids to get a flu shot at the GP, who notices bruises on Fiona's arms. The GP asks Fiona if things are okay at home. Fiona tries to tell her GP what is happening, but can't find the words, so ends up saying nothing. One day at work, Fiona called the police for advice. She recognises the officer on the phone and as a friend of Michael's from the football club, and tells the officer that she and Michael have been arguing and that she is worried about the kids. The officer tells Fiona that Michael is a good bloke and probably doesn't mean it. Fiona decides to take the children out of school and goes to stay in a motel for a week. She tells Michael he needs to speak to his GP and that she won't come home until he deals with his anger issues. Michael calls Fiona repeatedly at work and on her mobile and refuses to acknowledge he has a problem. He says he will do anything to keep her and the kids together as a family. Fiona runs out of money, and the school has been calling to find out when Fiona and the kids will be back. Fiona doesn't know what to do next, so she returns home. Initial police response. Fiona returns home. Michael is angry that Fiona has tried to leave him with the kids. He tells her if she tries leaving again, he will kill himself. He also threatens to take Fiona to court and tell Child Protection she is mentally unstable and abusive. Michael takes Fiona's car and speeds off into town to a function at the football club. Fiona is scared and feels isolated on their rural property. She is not sure what Michael is going to do and worried about losing her children. Michael gets home drunk a few hours later. He has driven the car home. Michael grabs Fiona by the neck and pushes her up against the wall. The neighbours hear Fiona yelling and crying and call the police. The police attend, and an officer takes Fiona aside and asks if she is okay. Fiona is scared of what Michael might do and embarrassed, so says it was just an argument that got out of hand. Police record the incident as a non-violent, verbal, emotional. Michael isn't asked to leave the house, and a family violence safety notice is not issued. A few days later, the police are once again called to the house in response to a neighbour's complaint. Fiona has locked herself in the bathroom with Brody and Georgia, who are crying when police arrive. Fiona is highly distressed and refuses to open the door until Michael is out of the house. The police complete an L17 form and a family violence safety notice is issued. Michael is excluded from the family home, and the police refer Fiona to the local specialist family violence service, to the specialist family violence service, the Centre for Non-Violence.
Throw now to Sergeant Singh. Police are the first on the scene when there's a call out for a family violence incident, and in some parts of the state, police estimate that they spend up to 60% of their time responding to family violence. Could you tell us what is the police response in regard to family violence, and what happens when police are first called out to a suspected family violence incident? What are police required to do?
So the police response to family violence is governed by a document called the Code of Practice for the Investigation of Family Violence. It's a Victorian police document, but it is, able to be viewed online. If anyone wants to have a look at it, it's there. And basically the role for police in family violence situations, there's three main functions listed in the Code of Practice, and that is to maximise the safety of the affected family member or victims in this case, to give them support, also to identify and investigate, prosecute any criminal activities within the incident. And the last one is to assist in prevention and deter further violence happening, which is quite often the civil option that we may take by taking out intervention orders or safety notices. When police attended a scene, it is very difficult because all parties involved in that incident are usually at heightened. You know, their responses are heightened. So the first role of the police is to quieten everything down and try and get the story of what's happened during that incident. They will assess it. As stated, they will do a form called a family violence report or an L17. And through that L17, that form itself is a risk assessment, preliminary risk assessment form. Once that's completed, that will determine what they will do in relation to the incident. So the family violence risk assessment or the L17 risk assessment form will dictate really what they have to do. So it may be there's criminal charges, it may be that there needs to be an intervention order, or it may just be a fact that, you know, it's been a verbal incident and there may just be referrals made to appropriate services.
Would you be able to tell us, how do police assess who's the victim and who's the perpetrator in a family violence incident, and what else do the police look for?
That's a very difficult question. We do have training in relation to working out who the primary aggressor is, and we don't always get it right, I will say that, but, you know, 9 times out of 10 we will get it right. So we just look at who's got the most fear, I guess, who's being the most aggressive towards the other party, just the normal signs that you would look for.
And can you tell us what the police are required to do in relation to the children who are present at a family violence incident?
Yeah, the children in a family violence incident, if they are present, the police will do a separate risk assessment for the children, so they will ensure that their safety is looked after as well. If there's been physical or sexual assaults on the children, it is mandatory that we report that, and we report that through to the Department of Health and Human Services and also to our local sexual offences and child abuse investigation teams. So that's mandatory. If we believe that there's been some significant harm done to, or significant harm to their well-being, we can also report that through to Department of Health and Human Services. But if we believe that we've just got some concerns for the children, we may also refer through to Child First for some counselling.
Now, we'll recall that Fiona had some difficulties when she first tried to speak to the police about these matters, and she didn't get a positive response. What are Victoria Police doing to make it easier for women to report violence and to improve the responses?
I think you'll find, certainly over the last 10 to 12 years, there's been a huge shift in policing family violence. I go back to my time on the van, which was quite a few years ago, and we'd get called to a family violence incident, and really we were there just to stop a breach of the peace. You know, there was no real follow-up. Now the system has changed completely. The Code of Practice is guiding us in what we have to do, and I think, we're all aware of what we need to do. We've had, since Family Violence Command came on board approximately 3 years ago, we've had a lot of new training regimes, family violence training in a number of different areas, which is really helping the members, to go out and be able to deal with family violence incidents. This training has been made mandatory, which not all police training is mandatory, but the family violence training was made mandatory. And of course, since the Royal Commission, the recommendations coming out of the Royal Commission for Police, we've had quite a few, things happening. We've now got a Centre of Excellence for Learning in family violence. So they're working on all training, both from recruit level right through to every member in the police force will be receiving new training. We've also had the inception of family violence training officers, which are now not based in Melbourne, but they're based in one in each division. So there's one training officer in the Loddon Campaspe region. And we've also now got family violence investigation team, we've had family violence teams for quite a number of years, but this is the family violence investigation teams are going to be investigators, and they're going to be looking at the high risk, high volume family violence perpetrators, and really keenly looking at them.
All right, and finally, what would the police response be to Michael in this situation?
Well, as you heard, they took out a safety notice and have excluded him from the home. The other thing that police will do, they'll look at criminal charges, so there may be some assault charges, but certainly the intervention order process, and they would also be referring Michael on to services to help with prevention of further offences. So that may be through to Cate at Men's Behavioural Change, it may be through drug and alcohol services, mental health services, depending on what problems there seems to be.
Thank you very much. If we could move along to Cate now. The police, of course, in this matter have referred both Fiona and Michael to the Centre for Non-Violence, who are a specialist family violence service in Central Victoria. And they provide services both for women and children experiencing family violence and also programs for men who are using family violence. Cate, can you give us a bit more of an idea about what constitutes family violence and also what types of violence are mainly used, and who usually experiences family violence, and what is the definition of family violence? That is a big question. Sorry about that. Break it up. What constitutes family violence and what is normally used as violence?
Well, what constitutes family violence is a pattern of behaviour where one family member has used a pattern of behaviour over a period of time that has caused fear in the other family member. And I think Mary set up a really good foundation for today in talking about the types of violence, so physical, sexual, psychological, verbal, emotional and spiritual. And it is deemed in a pattern of behaviour that has the impact on the family member, causing fear or emotional well-being impacts that cause people to fear for their safety. So the next part of that very in-depth question, please, Kylie.
Actually, look, you've already covered it really in your answer there, so we'll move on to the next one. What are some of the signs that Fiona, in our case study, was experiencing family violence, which her friends and family may not have picked up on? What sorts of things might we see as family and friends of people who might be experiencing family violence? Okay, so right from the onset in this case study, where it started off in describing that Fiona and Michael had been married for 10 years. So right from that point, it was evident that Michael was setting up conditions to establish isolation for Fiona, which is a really significant risk factor in identifying family violence and predicting further risk of family violence. So as the case study identified, Fiona had been isolated from her family since marrying Michael. So that's been 10 years of isolation, and that was based on that Michael didn't like Fiona's family and he refused them to visit the property. So when we talk about isolation, we're talking about social isolation and also geographical isolation. The location of Michael and Fiona's home is on a rural property on the outskirts of Maryborough. So we have both those factors there, social and geographical isolation. Then the next area that it identified further isolation from any form of social or supportive networks is that Fiona had stopped working to raise the children. She'd become financially dependent on Michael and she lost contact with most of her friends. So Michael had created conditions where Fiona is not only financially dependent on him but also emotionally and socially dependent on him. She has very, very limited networks. The only network that she starts to develop is when she returns to work. So that is the only place where she is not seen without Michael. So there's some of the things that family and friends may have started to pick up on, the loss of contact with Fiona through Michael's actions.
The other thing that's quite evident is that Fiona has making very strong attempts to cover up her bruises, has gone to the GP. The GP has noticed that. He's asked her what's happened. Fiona hasn't got the language or maybe feeling too ashamed to disclose. So that the bruising is a very clear indicator of violence, of family violence. So if the GP had some information around local services for Fiona, to ask her a couple of really clear questions, such as, have you ever or are you afraid of anyone at home? Creating some conditions where Fiona would have felt safe and secure enough to start to disclose. So they're just a couple of points that were quite evident in this case study, where family and friends may have picked up that there was family violence happening. And this has escalated over a period of time, but you can see there's been a pattern of behaviour that Michael has rolled out over a 10-year period.
So what types of challenges can women like Fiona who live in rural and regional areas face in coming forward and reporting and seeking help?
Yeah. Right throughout the case study, it's very evident that Michael has created a very positive profile in the community. So Michael is seen as friendly, generous and polite in the public arena, at work, at the footy club, right throughout the community. Fiona knows that, so that's very different to the way that Michael chooses to behave at home towards Fiona, which includes in front of the children. So where he's verbally abusive, he name calls her, calling her a bad mother, which Michael's behaviour escalates into physical violence. Fiona has thought of ways that she may seek help, but she's feeling that she may be recognised, the children may be recognised if she does seek help through the local services. So the shame and the fear that goes along with being identified as a victim of family violence and disclosing that is a significant barrier for women to seek services or disclose. So that level of fear and embarrassment is intensified in smaller communities where the family is known, and especially if the perpetrator, in this case Michael, is a very well-known member of the community and he has a very public, positive profile. Fiona has taken some steps to call the police, and in that attempt to disclose and to get some information, her response immediately closed down any service that she may have tried to explore to get some assistance. Research shows when women first disclosed, if they are not believed, they are unlikely to disclose again for quite some time, and that's quite evident in this case study. Fiona does not call the police. The times the police are called by the neighbours. So they're just a couple of examples of the difficulty and the challenges that Fiona faced within a small rural community.
So Fiona is referred to CNV by police. What are some of the other ways that women could get in contact with CNV or other specialist family violence services?
Okay, so as you've highlighted, police referring into the Centre for Non-Violence is only one stream of referral. So Fiona, if she was aware of the Centre for Non-Violence, she could have contacted the service herself. The GP could have referred in, and we're very open to secondary consults from other professionals or family or friends where we talk about the services that are available and the ways that we can assist women to reduce the barriers to access services. So it may not be that Fiona would have come into where CNV are located at Maryborough District Health because of Fiona's fear that she may have been recognised, and there could be the public awareness of what's been happening to her as a result of Michael's behaviour. But there may have been some opportunities to discuss where Centres for Non-Violence may have been able to attend somewhere where Fiona would normally be going, so it can be done in a much more discreet way to try and reduce that sense of embarrassment and fear that the community will know about Michael's behaviour and what that means for Fiona and the children. So there are just a couple of examples. So if Fiona had chose to disclose to her employer, that's also another avenue. So from any professional or public area, contact can be made. Yeah.
What other supports could you provide to Fiona after receiving the referral, such as in your risk assessment and safety planning, and how do you go about assessing that risk and priority?
Okay. So risk assessment is ongoing and dynamic. So we have static risk factors where we gather information and that would be gleaning all the information that has been provided by the police on the police referral report, which is the L17 document. Information be gathered from there, and then it would be through gathering information around Fiona's experience, past and current, because risk is dynamic. Future risk is based on past behaviour. So we would have been, asking lots of questions around what has Fiona done in the past when she's felt unsafe? What does she think Michael is capable and likely to do? Because there's three elements of conducting a risk assessment, and that is the woman, the victim, Fiona's sense of risk, evidence-based risk factors, and professional judgment. So when we have gathered all that information, we analyse that to develop a tailored safety plan for Fiona and the children, and to apply a risk management framework to monitor the risk. Because at this particular stage, the risk is high, and it is likely to increase, because not only has Michael had a system response where the police have become involved, but his use of violence is now becoming quite public. He's going to court, so the risk for Fiona and the children has increased. So, as I said before, risk is dynamic, and we need to monitor the factors that influence risk, which is the behaviour becoming public, any other sanctions that Michael may experience. There may be repercussions from him at work. There may be repercussions from his footy community. He has been excluded from the home. So any of those influences on risk need to be monitored and taken into consideration on how that's going to impact on the current safety of Fiona and the children. So risk assessment is ongoing and needs to be constantly checked in. And safety planning. Safety planning is tailored to the needs of Fiona and the children. So looking at, she's living on a rural property, whether that's safe for her to stay out there with the children. Some of the things that would be considered in this situation would be, is how likely is Michael to obey the order? Is he likely to breach the order? And Fiona is going to have a really good sense of that. She knows him, and she knows his current emotional state and what he's likely to do. So those things are really important in identifying and managing risk. So it may be options of short-term crisis accommodation until there's some safety measures put in place, which may include a technology response, including cameras, where Fiona and the children can return home to feel safer in the home. There may be reconnection with family and some friends, making sure that the school is aware of the current intervention order. So if Michael does come to the school or Fiona's workplace, that other professionals are able to enact that order by calling the police and reporting a breach of the order.
Could you tell us, lastly, what services might be available for Michael following the response by police? What supports are available for him, and also what supports are available for Brodie and Georgia?
Okay. So, as you clearly identified earlier, Kylie, the Centre for Non-Violence provides services for women and children experiencing family violence, and also services for men choosing to use family violence. So we would provide a response to Michael to talk to him about support services that we do have available, and that includes case management for men who are excluded from the home due to the use of family violence. Also the Men's Behaviour Change Program, which invites men into view their current behaviours and belief systems and the impacts of their behaviour on their family members. Men's behaviour change is based on the safety of women and children. So we could work with Michael on emergency accommodation, doing some work with him around identifying if there's any referrals that need to be made, such as alcohol and other drug referrals, because it was noted that Michael had been out and was drinking, so whether there's any alcohol misuse. Michael had also threatened suicide, which also is another high risk factor that needs to be considered in relation to risk assessment and management. So whether there's any undiagnosed mental health issues, so Michael can be linked into a GP mental health plan. Look at his ongoing housing needs, whether there's opportunity to support Michael in getting him linked in with appropriate housing to create some stability for his housing situation.
We'll throw back to Amanda now, who's going to talk to us about the intervention order process for this family.
Fiona and Michael attend the Magistrate Court on the day notified on the Family Violence Safety Notice. Fiona is feeling anxious about seeing Michael at court, but has been informed by the police that she needs to attend. Fiona has spoken to the Centre for Non-Violence about the history of violence in her relationship with Michael, and a worker is at the court to support Fiona on the day. Michael does not have a lawyer, so the registrar at the court suggests that he speak to a duty lawyer from Victoria Legal Aid, who is at court on the day. The police application for a family violence intervention order lists the children as being protected, as well as Fiona, and has the effect that Michael cannot see them, go to the family home, or come within a certain distance for the school, which is also Fiona's place of work. The magistrate asks Michael if he agrees with the order, but he denies that he poses any risk to Fiona or the children and says he wishes to fight it. A directions hearing is set for 5 weeks later. Michael must not approach Fiona or the children until the hearing. Michael can contact Fiona about parenting arrangements, provided this is in writing only via email, text or through a lawyer, and that he does not commit family violence when doing so. Michael goes to stay with his mother. Brodie and Georgia have not seen their father since the police attend the house some 6 weeks earlier. Michael is growing more frustrated that Fiona has not contacted him about arrangements to see the children. He uses his mother's phone to send her an angry text message telling her that she is using the children against him and that he will take her to court and make sure she never gets custody. His mother calls Fiona and begs that she let Michael see the children and take him back. Fiona does not report this to the police, as she doesn't think this is a serious enough breach for police to respond, and is worried what he will do, and she has no evidence that the text is from Michael. She is worried that Michael is manipulating his family and others against her. Back at court for the final hearing, Michael reluctantly accepts a final IVO on without admissions basis.
So, in addition to providing legal protection to people affected by family violence through family violence intervention orders, courts increasingly are becoming a hub where survivors and perpetrators can be connected to justice agencies, treatment agencies and community-based support agencies. If I could throw to His Honour Dr King, could you briefly explain the family violence intervention order process to the people here, including the difference between an interim and a final order, and what considerations the court will make in granting an intervention order?
The intervention order process begins with an application. It can be by police or by a victim of family violence. The focus of this exercise, and indeed of today, has been on intimate partner violence, man on woman, and that, of course, is the bulk of our work. But we also deal with other forms of family violence. So each week, at least, we deal with some elder abuse, mainly parents seeking orders against drug, ice-addled children who have been abusive. We also do some occasional sibling violence and also some extended family violence. So I heard an application by a niece against an uncle the other week. And occasionally we get same-sex couple violence as well. In this case, the police issued a safety notice that, under the Family Violence Protection Act, becomes an application for an intervention order. So that would be lodged at the court, as it has in this case, and it would come on before a magistrate. The police could also, well, in this case the safety notice was the way they proceeded. Michael could have also been placed on bail to appear in court, or if it wasn't an immediate crisis situation, the matter could have proceeded by way of summons. An applicant or a victim can also apply themselves, and so we do get a mixture, mainly police applications, but we also get victims themselves coming into court. So before the incident where the police were called, it seems to me there was enough in that scenario for Fiona to actually have come to court herself and applied for an intervention order. Both at the interim stage, well, there are two forms of orders. There is an interim order, which is put in place until the matter can be finally determined. Commonly, interim orders are made in the absence of the respondent, although the respondent in some cases will be there if they've been served and they decided to come along after receiving the safety notice. But where a victim themselves apply, generally it's in the absence of the alleged perpetrator, and the court can make an order ex parte, that means without hearing the other side, until the matter is determined. So the court in that situation, if there is grounds, will make an order that until final order or until a specified date, these particular restrictions apply. The respondent is bound by the order once being served. On an interim hearing, the court doesn't need to hear oral evidence. If there's affidavit evidence, and the applications commonly can be in the form of an affidavit, then the court won't require a victim to go into the witness box. It is in the discretion of the magistrate, but my practice is if there's enough material on the in the application, I won't require the victim into the witness box. On police applications, particularly the initial ones, the victim may not be, the affected family member may not be there. The court, both at the once the matter is finally determined, that is at the end of the proceedings, if it's settled or if it goes to a contested hearing and a magistrate makes a finding on the facts, then the court can make what's called a final order. So this is the order at the end of the proceedings. The court fixes a period that the order applies for, explains the order to the respondent, and the respondent is bound by the order. At both the interim and the final stage, the court is primarily concerned with the safety of the affected family member, in this case Fiona, looking at assessing whether there is the need for an order to be put in place to ensure the victim's safety and or to protect the victim's property, so their personal safety, or protect their property. So the court is really looking at a risk management situation, as are many of the agencies who are involved in family violence. And in this sort of scenario, the court relies heavily on the material the police bring to court as to the risk factors involved. And often we will adjourn cases for police to do risk management and advise the court whether the matter should proceed further. So the court will look at the history of the relationship, how frequently there's been family violence, the nature of the family violence, when was the last scenario involving family violence. If the last situation was several years ago and there hasn't been anything since, then the court may conclude that it's unlikely that there's going to be the need for a family violence intervention order. In this scenario, you have a history of family violence, you have recent incidents of family violence, and perhaps escalating, and clearly there is the risk involved. So the court in this scenario would clearly grant an interim order, and if it made the findings of fact at a final hearing consistent with this scenario, then it would make a final order as well. Have I answered all the aspects of your question?
More for you.
Oh, goody.
So can you tell us all what are some of the more common conditions that you'll find on intervention orders, and can any of those conditions include a requirement that the perpetrator undergo counselling?
Very good point. In relation to the common conditions, the primary condition is that the perpetrator not commit family violence against the affected family members. And I should say that in making these orders, the court must, under the Act, if there are children of the affected family member, consider the risks involved of family violence to children, and will include the children in the order unless it's satisfied that there is no risk to the children involved. And commonly the children will be included as affected family members on the orders. So family violence is specifically defined under the Family Violence Protection Act. So we look at a legal definition which is under the Act. So it can include include assault, sexual assault, threats, harassment, emotional abuse, economic abuse. It is a very broad definition. So we quite often get applications that involve no physical violence, but might be the perpetrator sending hundreds of text messages to the affected family member, and that would be sufficient to ground a family violence intervention order. Other conditions: not to intentionally damage property or threaten to do so, not to contact or communicate with the protected person by any means, not to publish on the internet by email or other form of electronic communication any material about them, so not posting to Facebook or Twitter or any of the other various social media forums. That we can exclude a person from the home, and this is a common condition: not to approach or remain within 200 metres of a particular address, although in places like Maryborough we have to be very careful about our distances. When I was sitting in Western Australia, I saw an order that effectively meant in a small country town the perpetrator couldn't go to the shops at all because a particular 200-metre radius of a particular address that he was excluded from included all the shops in the town. So the court has to be very careful about how it drafts orders so that they're very practical. Another condition is that not to allow anyone else to do something that the respondent can't do under the order, so he can't get one of his mates to go and do something that on his request. Not to approach or remain within a certain distance of the person, not to go to their workplace or school. And these are the fairly common conditions that we include on the order. The court will exclude a perpetrator from a home, particularly if the affected family member wants to reside there and there are children. The court looks primarily to the safety and stability of the children and the affected family member over and above the interests of the respondent, even if the respondent has the primary proprietary interest in that property. That can be overrun by or overruled, so to speak, by the intervention order. The court also has power to suspend or revoke orders to do with children under the Family Law Act, particularly if the perpetrator has an order for contact and the children have been subject to family violence, and the court will look at suspending or revoking any orders in relation to the perpetrator seeing the children, or it can do so until a particular period, until the matter can be further resolved. We don't commonly make those orders here in this region because it's not often that they do have orders. Commonly they don't, so we don't need to exercise that power very often.
What are courts in this region doing to create a safer and a more therapeutic environment for people affected by family violence? And in your view, what reforms are still needed?
Very good point. In our region, we're constrained to a large degree by our architecture. In almost all of our towns, we have historic old court buildings which we can't really interfere with due to them being heritage listed. So what we can do in those sort of structures, such as the beautiful court at Maryborough, is quite limited. But recently the court has introduced security for each sitting day of the court. So you may have noticed outside Maryborough Court now, when it's sitting, the security guards and people are screened when they go into the court. This presence of security has had an immediate effect in making things a bit safer. When I was sitting out here a few months ago, there was a huge commotion outside the registrar's office, and I later heard that the security had called Maryborough Police because a perpetrator was causing trouble. So the presence of those security guards was able to lead to the police being involved very quickly to remove that person who was creating problems. In Bendigo, there is a proposal for a new courthouse. When that is finally constructed, it will be state-of-the-art with facilities for victims, separate entrance, separate place for them to be while their matters are being heard, both in the criminal division and the civil family violence issue sections of the court, and will have more child-friendly spaces as well. We also in Bendigo have applicant and respondent support workers who work with the parties and connect them into support services, connect them to lawyers, and give them advice about the processes. We don't have that out at the circuit courts, unfortunately. Ideally that should be made available, but that is subject to government policy and government funding, which is beyond the judicial and administrative arms of the court. So those are areas which ideally in each of the circuit towns of the court there would be more victim-friendly facilities, there would be greater supports at court, but because there isn't, we're very grateful that we have the support of services such as the Centre for Non-Violence and the Community Legal Centre and other agencies in the community that to some degree fill the gap.
To the next step now for Fiona and Michael, and they're going to move into family dispute resolution.
Kylie, I didn't answer one part of your question about the counselling programs. In criminal, we can port people, get perpetrators into counselling as part of our sentencing process on community corrections orders. We also have the ability to put people on bail with conditions they engage in treatment. We commonly make conditions that people engage with the Centre for Non-Violence, perpetrators engage in a men's behavioural change program, and if it's a condition of bail or on an undertaking, we require them to provide proof of compliance with that to the court at the end of the undertaking. In intervention order matters, only declared family violence divisions of the Magistrates Court can compel people into being assessed for suitability for counselling, or able to, or then to order them to engage in counselling if they're suitable. At the moment, there's only 4 courts in the state that can do that. They are at Heidelberg, Melbourne, Ballarat and Shepparton, which are pilot courts for a more comprehensive family violence court.
I might indicate, though, that Ballarat's been a pilot court for about 13 years now, so it seems to be a pilot that's going pretty well, and we hope that it'll expand to the rest of the state. Over to you, Amanda.
Fiona contacts the Loddon Campaspe Community Legal Service and Victoria Legal Aid for assistance, but due to her part-time income and partial ownership of the family home, neither service is able to assist her. Fiona borrows money from her mother and seeks assistance from a private lawyer in Ballarat. She takes a personal day from work to travel to Ballarat to speak to her lawyer. Fiona's lawyer advises her of her options: mediation or family violence dispute resolution, to agree to a parenting plan with Michael, or an application for parenting orders through the family court. Fiona is willing to go to mediation with Michael and to offer that he sees the children a couple of afternoons a week and take Brodie to football practice if he agrees to complete men's behaviour change to gain insight into his behaviour and how it affects their children. Michael has been doing research online and believes that Fiona is using the children against him, and to provoke him, he refuses to engage in the mediation process or acknowledge that he possesses any risk to the children. A Section 60I certificate is issued to Fiona stating that attempts at mediation have failed due to Michael's refusal to engage.
Next, we'll move on to Dr Rob Southgate. Could you tell us what challenges people in rural and regional areas face in accessing legal assistance for family law matters?
Okay, so some of the challenges. I think it's hinted back there in the narrative that neither our service nor VLA could help. Now, the difficulty around that really is in small communities we might come across the concept of being conflicted out of assisting. So if either party's been assisted by either legal service previously, we might not be able to act for the parties going forward. It's just a difficulty in small towns, I guess. I suppose the other difficulties is accessing assistance on the day. For one reason or another, there might not be a duty service that's being provided to the court. Certainly in this area there is, from our service and both Victoria Legal Aid.
Moving on to the family law side of things, could you tell us what's the difference between a parenting plan and parenting orders?
So in essence, a parenting order is something that has been through a litigious process. So it's something that's, I suppose for want of a better description, is conferred upon the parents by the court. There's been a legal process put in place. A parenting plan is something that parents can engage in if there's still an amicable relationship between them and they can negotiate how both children and parents are going to spend time with each parent. That can be agreed between the parents before going off to the court to get an order. So in essence, a parenting plan can be agreed between the parents, and if they want to engage a lawyer, they can engage a lawyer to do that and assist them with that process. But otherwise, if it's an order, it's something that's directed by litigation.
So in our case study, Fiona has attempted mediation, or as it's also known, family dispute resolution. Is that process compulsory? When can it be excluded, and what support is available for people undertaking it?
Okay, so it is compulsory. I mean, if people want to go off to the family law courts or the federal circuit courts to get a de novo parenting order, then they will have to engage with the family dispute resolution mediation service or intervention first. Under what circumstances can they be excluded? Well, if a particular person is feeling quite anxious about engaging in that process, then that can be managed by way of a shuttle mediation. So parties don't necessarily have to appear in front of each other and be undertaking that process face to face. They can do that via a shuttle telephone mediation. What other supports are available for women to feel safe? I guess that would be the primary mechanism by which you can make a person who's engaged in a mediation process feel a little safer. Quite often mediation services won't engage with people unless there is an interim order in place or some sort of order that highlights the need for there to be a lens on the family violence that's occurred in the past.
In our situation, Fiona was given a Section 60I certificate. Can you tell us what that means?
So in terms of my practice, I commonly see that when one or the other parties hasn't engaged in the mediation process. So you have one party who has tried to mediate a parenting plan such that both parents can have contact with the kids. And more often than not, I see it in terms of one parent not being willing to engage in that process. So a 60I certificate will issue, and that will allow the parent that has engaged in the mediation process to take the matter to the family court.
All right. Now, in this situation, there's a family violence intervention order in place, and it says that Michael can't see the children. Can he still apply to have contact with them through the Family Law Act?
He can. I mean, generally, if there's an intervention order in place, the decision maker, the magistrate who's put that intervention order in place, will turn their mind to whether or not there needs to be what's known as a Section 92 clause included in the order, which would allow Michael to have contact if that contact is agreed by some written form, whether that be a text message or an email communication. But he would only be able to do that if he didn't perpetrate family violence whilst in the course of conducting those negotiations. So it seems to me here that there's been a no contact order. A decision maker has made the decision that contact can't occur because there's been too serious a family violence incident. So he can still make applications to the family law courts to get access to his children, yes. But again, he would have to engage in that mediation process.
In a rural and regional area, what are some of the challenges that parents face in terms of trying to arrange contact?
I suppose geography primarily. In a situation where you have a mother fleeing with her children, she might move geographically to a location that's distal to the father, for example. I know many of our clients in this region certainly have difficulties travelling outside of their town. So it would be just those day-to-day issues of being able to conduct your work life, pick up the kids, drop the kids off, have changeover, and make sure all those scenarios are safe.
All right, we're now going to throw back to Amanda again, who's going to talk to us a bit about, for Fiona and Michael, their family law proceedings and attempting to get parenting orders.
Fiona's lawyer advises her to make an application to the Federal Circuit Court for parenting orders and to provide the Department of Health and Human Services, Child Protection, with a notice of risk about Michael's behaviour and lack of insight into the impact it has on his children. Brodie has been acting up at school and Georgia has become increasingly withdrawn. Brodie says he hates Dad but can't explain why. Georgia has become increasingly attached to Fiona and anxious when they are apart. Fiona files an application seeking final orders that the children live with her and an interim order that a single expert be appointed to prepare a family report. Fiona's files a notice of risk in which she claims the children have been exposed to family violence during the relationship at separation, are at risk of being exposed to family violence if ordered to see Michael, who cannot control his temper, are at risk of being psychologically harmed if forced to spend time with Michael when they are expressed they do not want to.
I'll now throw over to Pamela Brown. We know that children are present at 1 in every 3 family violence incidents which are reported to police, and exposure to family violence can have significant impacts on child development and well-being. What are some of the issues that Brodie and Georgia might be experiencing having been exposed to family violence?
As I said earlier, we've identified what the symptoms of post-traumatic stress disorder are, which tend to be avoidance. You tend to avoid things that trigger memories. They tend to have a high level of anxiety, sleep disturbance, nightmares, emotional dysregulation. What happens for children and for all of us when we're exposed to a violent situation or a traumatic situation? We go into what we call the fight or flight response, and our body is flooded with chemicals to prepare us to run away or to fight. So if you're out in the forest and you meet a bear, all of this will happen. Your heart will race. You'll get ready to run. Your brain gets flooded with chemicals. Cortisol particularly is one that we use in our fight or flight response. And that's quite normal. But also normally, once you're out of the forest and you're away from the bear, you slowly resolve. You know, your brain moves forward. It all settles down. But if the bear comes home every night, you are constantly in this state of fight or flight. You can never calm down. You can never relax. And that's what happens for children when they're constantly witnessing family violence. And a lot of people don't realize this, that they live in this perpetual state of fear. And that's what I was talking about earlier. When you live in that perpetual state of fear, you're chemically imbalanced. And that's where your long-term situations come from. Now, children often, as we see in the case of Brodie, he's the boy. He's a little bit older. He's acting out a lot. He's just has no emotional control. Georgina, unfortunately, has shut down, or Georgia. And a lot of children do that. They just simply shut down. They're flooded with chemicals. They can't react. And they seem very well behaved. But what's happening for them is they cannot engage socially in school. They cannot learn things. They cannot access a lot of the services that are there to help them because they're just in this state of frozen fear. The other problem, too, with children is they often take responsibility for things they cannot be responsible for. If their parents are fighting and arguing and they keep thinking, there's something I'm doing wrong, and they don't have the capacity to see that they're not responsible for what's going on with their parents. And so there's a lot going on for children that we often don't see. a sense of not being able to protect their mother, to watch her constantly being terrified and not being able to do something about it. And I think probably for the Brody, that would be a particular thing for him, possibly. The other thing that happens, I think, with these children, too, is because their home life is so chaotic, they're often vulnerable to predators, unfortunately, and I've seen that a lot in private practice, that other people will sense that they're vulnerable, that they're not in a protected home environment. And you often see them as the victims of other predators, sadly.
What support services are available for parents and for children affected by family violence, and what should be provided for them in your view?
Now, I'm probably going to have to defer to other people on the panel because I did not get my list of questions until this morning, so I didn't have time to research what was available in Maryborough. But certainly there are a lot of really good services around Victoria. I'm from Melbourne, so I haven't spent much time in this area of Victoria, and I was in Canberra before that for 30 years. But I do a lot of work, consultancy work with Berry Street in Melbourne. I've been working with the Child Adolescent Sexual Assault Service in Bendigo, and there are just some really great services out there that do work with families in the family therapy context. And certainly in the last few years, there's been quite an interest in being trauma-informed, and so there's a broader way of looking at children's issues and family therapy issues. So there's some excellent counselors, family therapists, social workers out there, and I'm sure they're well organized in this area of the country and are getting better organized always around this area. So if somebody else on the panel can add. Yep.
I could add to what Pamela's just been talking about. So the Centre for Non-Violence also has a therapeutic program stream which provides therapeutic counselling to women who have experienced family violence. We currently have our children's program under review, but there has been in the past opportunities for children to be linked in with therapeutic counselling due to their experience of being a victim of family violence. So that's currently available through the Centre of Non-Violence. Just to give a little bit of a local context, yeah. There's also Women's Family Violence Support Group, which operate in Bendigo, and I know there has been one that has operated out in the Maryborough region. So they're things that are constantly being explored within this area based on the resources that are available in developing up appropriate resources to respond and provide recovery programs for women and children who have experienced family violence.
And I think one of the main things for children, I think eventually they need to be treated for the trauma, but first they need to feel safe. And so these organizations that provide the family therapy, that's incredibly important. I think one of the real issues in family law is how long it takes for it finally to be resolved in trial, and that 12 months, 18 months, which consistently creates that tension in the family, and that constant pervasive sense of fear is detrimental to both the mother and the children. And to have to live with that for such a long period of time is difficult, because until those children feel safe, until they know they're physically safe, they won't be able to relax and engage in any sort of help they get. It's just a protective service until they can actually feel that sense of safety.
Thank you very much, Pamela. Finally, how can children be engaged in the mediation or the court proceedings to have a voice and express their views without further compounding their trauma?
I think that's a difficult question, and I think that's particularly difficult in the age of these children, because children are incredibly loyal to both their parents. And even as dysfunctional as they are, to cut off your parents is to cut off your lifeline. And you haven't, particularly at that age, you haven't got the analytical ability to see the whole picture, to see what's going on for your parents, to see what's going on for you. All you know is that if you cut off your parents, that's it. And I've seen children really conflicted, because even though they are fearful of their father, they're fearful of what's going on, he's still their dad. And for a child to say to their father, "I never want to see you again," at that age, is pretty traumatic for them. It's just not something they can do easily. So, particularly in the case of these children, I think it would be a difficult thing to put them through because it's something they have to live with the rest of their life. And often those fathers will come back and blame them the rest of their lives and make them feel guilty and responsible. So I'm not quite sure how you would put them in the mediation process, what there is now. I mean, I've seen it happen with family court. Often it used to be, back in the 80s when I was divorced, you had children, I think, generally had to be about 14 before their opinions were considered. And I think it's still reasonable not to ask young children to try to make adult decisions when they don't have adult brains.
Could I just add on to programs that are available? I just wanted to add in that the Centre for Non-Violence also provides a recently developed and funded through the Departments of Justice Making Amends program for fathers who've used family violence to become a better dad. So that's a new initiative by the Centre for Non-Violence. So we've got some flyers here. So that's also another service that's available through the Centre for Non-Violence, because we do know that both women and children want their kids to have their dads, but it needs to happen within the context of safety, that it's conditional, that children need to be provided with a safe environment to have a relationship with their dad. So this is one program that has been developed up to create an opportunity for men that would like to come in and work towards creating a safer environment to have contact with their children. So that sits alongside Men's Behaviour Change program, which is inviting men in to take responsibility for their use of violence and work towards making conditions for their family much safer, including current ex-partners and children. So they're also, if you want to look at programs that are available to parents, so that's for mums and dads and children. So they're just an overview of the programs that are available across this region.
Look, I think this is an area that hasn't been explored, and that is the needs of children in these situations. I was looking up child abuse statistics in Australia a few weeks ago, trying to prepare for this, and there hasn't been a lot of assessment of exposure to trauma of children in Australia. There's been quite a bit overseas in the US and the UK and Wales and Canada. And looking at children exposed to trauma, there are 10 categories. There's things like family violence, there's things like sexual assault, abuse, neglect, criminal activity in the home, that sort of thing. But the highest areas of exposure to trauma for children is family violence and witnessing family violence. And we haven't really quantified how much of that happens. I mean, I think, as Mary said, 50% of women who experience family violence do have children, but we haven't really done a lot of research from the child's perspective in this area. And hopefully that's something ongoing that can happen and will happen in the future. I think this whole area of family violence, we keep adding, as soon as we kind of get close to getting somewhere, we add another bit and we add another bit, and that's what we have to do. When we're looking at prevention, we've got to look at the needs of children in all of this. But we need to do what we're doing now, which is look at the causes and then start looking at the prevention from a child's perspective.
Thank you, Pamela. I'd like to move on now to Liz. In terms of Anglicare Child and Family Services, how might family services become involved with a family like Fiona and Michael's, who is experiencing family violence?
Well, there's a couple of ways that we'd become involved. Firstly, there'd be a referral through to our Child First, which is our intake area, and then a referral would likely come through to one of our family service programs. So we have a family service program here in Maryborough, and what we're working on in family services is working with parents to help them address any barriers towards or any issues around their parenting. Family violence would be one of the most common common areas across all the referrals that we see across the region. It's a very big area. So in this particular case, I mean, one thing I just want to say, I was really pleased to see where it says on the previous page about Michael's behaviour and lack of insight into the impact of his violence. I can't tell you the amount of times we get a referral document or orders where it says mum isn't aware of the impact of family violence, which I find an amazing statement to see written on paper, that the mother living the experience wouldn't be aware of the impact of violence. But often and I guess I was thinking about that this morning when we were talking about the language that we use. That sort of language in documentation has just got to stop, because it's blaming mum. And we're victim blaming. So, sexual assault and family violence are one of the only areas of the law where the victim gets blamed. So I just wanted to note that I was really happy to see that it was Michael's behaviour and lack of insight that was being talked about in this example. I think that's a positive thing. So although we work with the parents, the clients in all our cases are actually the children. So in this particular case, I can see it's previously said about when Fiona had tried to leave and things got difficult and she returned. That's a really common thing, and we see that a lot in family services. So for me, I think we'd be looking at what are some things we can do to help work with Fiona that's less likely to happen. So that's around safety planning, that's around linking mum into supports, linking the children in, as the doctor was saying, around at the psychologist? Sorry, good. Okay, around the importance of linking the children in and getting their voices heard. So we might do that through linking them in with play therapy, a space that's just for them, a therapeutic space. But in family services is a little bit different because we work with the whole family. So often we work with families where the perpetrator is still in the home. So that's slightly different here, but doesn't mean down the track that Michael won't return to the home. The legal orders may change. Michael and Fiona may reunite. So we often are working with families where we're working with the whole family and the perpetrators in the home. In cases like that, we rely heavily on consulting with C&V and some of those areas to really look at how we can make sure that we're building a relationship with both parents and engaging in the conversations and saying we are not okay with that behaviour and we won't tolerate it, but not colluding as well. Often, I've in lots of cases I've worked on, it's actually been crucial to build a relationship with the perpetrator, even though I don't agree with any of the behaviour that's occurred. Sometimes to add to the woman's safety, he needs to let me in the home. He needs to be okay with me being there. So it's some of that stuff that's really tricky to navigate. Like I say, in this case, Michael's out of the home, but that could be a very short-term thing. So we need to look at linking Fiona into services. We've got a lot of therapeutic services in Anglicare, so we have emotional wellbeing groups where women can go and share their experiences. We have also counselling available. There's other things that family services would do as far as in this case, like helping the family to navigate the child protection system and the legal system, which is really tricky to understand, and the different points. And often we're an advocate in between child protection and the legal services with the parent, but it's also a really tight juggling act because we're always about the best interests of the children. But we also want to be strong advocates for the mums as well.
That was ideal because you answered the next question already.
Oh, okay, good.
Which was about what services Anglicare can provide.
Yes.
All right, so moving on to the next section of the case study, can we move on to what happens when there's a family report and the appointment of an independent children's lawyer?
At the first return data, the family court orders a report be prepared by a single expert. An ICL be appointed for Brodie and Georgia. Proceedings are adjourned for further direction following publication of the family report. The family report is published and states that both children have a strong attachment to Fiona, who has met all their needs throughout their life. The children should continue to live primarily with her. Michael lacks insight into how his aggressive and violent behaviour towards Fiona affects the children, making them scared and providing a poor role model for the treatment of women. Fiona lacks insight into how her behaviour, as opposed to what she says, influences the attitudes of the children towards Michael, i.e. she says that they should see their father, but they can sense that she does not trust him or want them to go. There are concerns Brodie might be mimicking his father's violent behaviour towards his younger sister Georgia. Child Protection have also investigated claims in Fiona's notice of risk and has substantiated that Michael exposed both children to family violence. Their report finds that children are not at risk with Fiona, as she has acted protectively by refusing to let them see Michael. The report finds that the children would be at risk of harm if they were to spend unsupervised time with Michael. The matter is listed for a Family Court of Australia trial.
Now I'll move on to Tim. An independent children's lawyer, or an ICL, has been appointed for Georgia and Brodie. Why would an ICL have been appointed for the children in a matter like this?
Yeah, well, first of all, can I say this is where the system is really stuffed, that this is the first step along the road, that the children get a formal professional voice. So you can see how late it is since the tragedy, since the initial violence and since the IVO, and the system's got to be fixed to give the children a voice. Now, what happens typically is that the lawyer for Fiona and the lawyer for Michael might ask, or the court of its own motion might say, this fits the criteria for the ordering the appointment of an independent children's lawyer. Independent is very, very strictly interpreted, and it must be understood that then that lawyer is independent of the court, independent of the parents, and most importantly, independent of the children. So typically then I'd get a phone call from legal aid, sometimes directly from the judge in very, very extreme cases, saying, can you take this on? Are you conflicted? And then an order would be made for my appointment.
And can you explain to us what is the role of an ICL?
Yeah, well, I know time's on the wing. I'd keep you to about midnight if I really told you the truth. But the role of an ICL is that, first of all, they are not, and I repeat, not the children's lawyer. They do not act on instructions from the children because, after all, that's too big a burden to put on the children. They are independent and they must act according to in the best interests of the children. Lawyers being lawyers, there is a definition in the Family Law Act, Section 60cc, which contains over 2,000 words telling us what two words, best interests, means. So I have to adopt that code of conduct. The role is described as counsel assisting a royal commission. I assist the court. I assist the judge in doing things that the judge might well like to do. And then throughout the process, I endeavour to come to resolutions in the matter, to meet with the children, to make the children feel safe, to test the evidence as an independent party, and at the end of the proceedings to explain the outcome to the children. So it's a very, very long and involved role. It's a fantastic role. It has its difficulties, and one of the privileges you get is to say to the parents, usually in the presence of the lawyer, that under the Family Law Act, this is my view, and I'm supported by judges older and younger than me, that you, Michael, you, Fiona, have no rights. Back in 2006, custody, a thing, access, a thing, went out the window. You, parents, don't have rights. The rights are with the children. You have responsibilities. Responsibilities means verbs, doing words, and the wording of the Act was changed to shall live with and shall communicate and spend time with. Not have custody like a salt shaker, not have access like a pepper shaker. And you'd be amazed after 2 or 3 minutes in speaking to parents in an adversarial context outside the courtroom, you just get them nodding and you get them almost eating like a horse eating chaff, finally understanding that they must do, not have.
Now, when you were chatting then, you mentioned the best interest principle. Could you expand a bit on what the best interest principle is?
Yeah, well, as I said, that's why we charge so much. We've got to read 2,000 words to define best interest. But the way best interest works is that there are two primary considerations. And initially when the 2006 amendments came, they were equal. The first primary consideration is the right of a child to have a meaningful relationship, not a relationship, a meaningful relationship with each of that child's parents. That's a primary consideration. The secondary consideration under the primary considerations, A and B, B is that the child must be protected from emotional and or physical and or psychological abuse. After the Darcy Freeman tragedy, the Family Court conducted its own inquiry and they changed the law slightly in saying to judges and therefore to court officers like myself, when in doubt between those considerations, the primary consideration must be the immediate safety and emotional welfare of the child. So that if the judge is in doubt, they've got to go to the immediate emotional safety and child safety ahead of the meaningful relationship. After those two considerations, you'll have a number of issues in the shopping list. Indigenous background, whether the parents are paying child support, etc., etc. The role of significant others, and the wording includes specifically grandparents, and then one interesting development occurred, and that is that they crossed out one pre-2006 words, one word, and substituted with another. Prior to 2006, my role and a psychologist's role was to get the wishes of the child. Finally, the court, with advice from the psychologist, woke up to the stupidity of putting the word wishes in, and that's now been changed by the words views. So you see how a child views the world, and the definition of views may, but not necessarily, include wishes, because the way our system was going was we were saying, oh, who does the child want to live with? And what a burden, picking up on what you said earlier, what a burden to put on a child, the decision-making process. So we now elicit the views. So that's how best interests is defined. There's case after case, opinion after opinion. But when we've got children at home at stake and their lives, we have to look at the subtlety of the definition.
And so what information would an ICL consider in determining a child's views?
Well, all we get at the start are the documents. He said, she said, and a copy of the intervention order. So we get dad's affidavit, mum's affidavit, etc. Now, what I typically would do would be then seek an immediate chambers order that I could serve a copy of the order on any professional body or anyone I thought had an interest in the life of this child. And what I do, and it was typical practice, was schools would get a copy of that order saying, I'm the independent children's lawyer and I am allowed to talk to you as a delegate of the court. And perhaps the GP, perhaps a psychologist, a sporting club, anybody, because red tape and the reluctance to be a whistleblower is just inculcated into all our institutions. However, if a knight in shining armour appears armed with a court order, that trumps privacy. And I can say to people, don't do the privacy card on me. I trump privacy. The welfare of a child is a stake. I want you to talk to me about that. And typically, Maryborough included, I travel to the schools, I liaise with the schools, and then I ask to see the child and to ascertain the views. Now, I'm only a lawyer, I'm not a psychologist, so I don't do, oh, did you see Dad hit Mum? How come the window got broken? You start off by finding who they barrack for in their AFL, or what their favourite TV show is, and then very importantly and subtly, and this is just a tiny example, you ask them about the pets they have. Now, quite aside from what we've been discussing today, I had 10 years on the board of the Children's Protection Society, a few years as president, and we sent out a student to do her PhD about the correlation between threats to animals and family violence. And it was astounding, and it is still astounding to me, as to what I learn in picking up the topic of the cat or the dog, and whether Dad's kicked the cat or the dog, or Dad's threatened to take himself out along with the dog, or it's only the dog that loves me. And you can then develop a conversation with a child. Now, my role is not psychological, but then I see how the child sees his or her world, and then you get into who else is in the family. Grandparents, uncles, aunts, who do they feel close to, who don't they feel close to? Then you get a sense of, is the child being forced to be a Montague or a Capulet? Is the child having to take sides? Or can the child rise above the various issues? And that's where, again, we pick up on another theme. Often the childs are parentified. They become the parents to protect their mother. They take on the role of protector in the household, and that's not what childhood's about.
Thank you so much, Tim. All right, we are very short for time, so we're actually going to move forward now because we've had lots and lots of audience questions come through.
Great. So we have really had a flood of questions, so we won't be able to get to all of them. I apologise, but we'll do our best to get through them. And I think I guess it points to the complexity of the issue we're discussing today, that this case study really only skims the surface of what this journey is like for a family. This is a question for the panel, and I think it touches on, Tim, what you've just been discussing, so you might want to jump in first here. Often children will very clearly express fear or anxiety about having contact with an offending parent. And so can children be forced to engage in supervised or other contact? How can their voices be heard and listened to? And how much choice do they have if they are very clearly expressing that they don't want contact with a parent?
Well, tragically, I think, and I say tragically, I think at the start of proceedings and early in the proceedings, they are normally ordered to spend time and communicate, but it may be under supervision. It may be under a supervised contact centre. My preference is to see if there are friends or family members with whom the children are familiar to engage in the safety of having an uncle or an aunt or a grandparent there who's promised the court that they will supervise. I also have seen children who are reluctant, and then you can negotiate. Kids are terrific negotiations, and so I should be on a commission, but we have the Mulvany movie and a meal suggestion where the kids see Dad at a movie centre. They go to the movie where they don't have to talk to Dad. They go for a hamburger or something straight after the movie, and it's a bit like going to the dentist. It'll all be over soon, but at least they keep up that relationship. But there are extreme cases where you say, particularly with teenagers, I respect and understand your view. We'll have to walk through it, and we'll walk through it slowly. But we're getting a little bit better, perhaps with social media, with allowing court-ordered text time and FaceTime where they won't physically be there, but at least they're in touch.
So the next question we have, thanks Tim, is what are the responses in this community for people experiencing violence in the LGBTQI community or in other relationships, such as elder abuse?
Depending on which way the client may be referred in, if the police are attending, there'll be a referral, but the Centre for Non-Violence can be contacted in relation to any of those diverse communities where there is intimate partner or family violence being rolled out, where there can be options and offers of resources talk through to those particular situations. in relation to diverse communities, as a result of the Royal Commission, the Common Risk Assessment tool, which has been the common statewide framework to work to assess, to identify and assess family violence, has been extensively reviewed and expanded out to include diverse communities, including COLD women, women with disabilities, LGBTIQ, Aboriginal and Torres Strait Islanders, to take in the significant and relevant individual risk factors that need to be taken on board in identifying, assessing and responding and managing the risks for those diverse communities, yeah. So Centre for Non-Violence is able to respond to diverse communities, yeah.
Yeah, I'd just like to add, most of the stations, police stations across the state, will have gay and lesbian liaison officers, and quite often if we get a same-sex couple, we will also refer through to our gay and lesbian liaison officers for them to do some follow-up with the people involved.
This isn't specifically family violence, but I guess something we've changed recently is even on our intake forms. Previously, we always had mother, father, things like changing that language to parent 1, parent 2. So I think services are slowly getting better at the way we engage with the LGBTQI community.
So this was a question directed to the panel. What is the panel's perspective on whether newly funded perpetrator programs in the region might potentially have an impact on reducing the need for family dispute resolution or family law matters?
I won't speak to the legal aspect, but what I can speak to is men's behaviour change. So I'll just speak specifically around the purpose and the intention of men's behaviour change. So men's behaviour change programs are specifically designed for men's use of violence towards family members. Violence is viewed within a broader power and control context. Focus is on the man's belief system, which is reinforced by the broader society and how that influences behaviour. Focus is on a man making a choice to use power and control tactics in order to gain or maintain behaviour. Safety of women and children is a primary objective of men's behaviour change programs. Men's behaviour change programs focus on men taking responsibility for his behaviour by acknowledging his behaviour, by examining impacts on women and children. So I don't know that it would reduce the need for those legal responses. Men's behaviour change is part of an integrated system to respond to family violence within our community as part of a system response. So I don't see that one part would probably negate the need for the other. So someone from the legal area or another panel member might like to add.
From another perspective, I do some work with addictions and sex addicts and whatnot, and I do it from a trauma perspective, because for many of these people, they have traumatic histories themselves, and their way of dealing with it is acting out upon it or getting triggered and behaving inappropriately. And there's been quite a bit of work overseas where if you deal with their trauma, then that puts them in the mental space to gain insight, much better insight from their men's behavior programs and everything else, if you can clean up the underlying trauma that is causing the misbehavior.
I'd just like to add that I think the initiatives are good so long as the person engaging in the initiative is doing it on a genuine basis, not just so they can be set up with a narrative to go and say that they should be afforded contact with their children because they've done this, that and the other program. It has to be genuine and authentic.
Could I just add to what Pamela has just raised? As part of men's behaviour change assessment, part of the assessment is to establish if there's some unmanaged past trauma, and that's identified, and it might be established at that point that the man, so if we use Michael for an example, that Michael is referred into some counselling to deal with his history of trauma, to place him into a space where he's able to come in to an environment where he takes up the opportunity to examine his behaviour and the impacts that it has had on his family members. Yeah.
Just from a policing point of view, the family violence teams that have been in vogue for a couple of years now have been using what we call a perpetrator intervention model, where we actually target the perpetrators, and we've seen significant reductions in recidivist rates across this division in the past 12 months that we've been using this model. So that's something that appears to be working.
This question was for Dr King. Are there situations where a family violence intervention order is made, but the affected family member and the perpetrator are allowed to continue living in the same house?
Yes, that's quite common actually. There might be an initial order with full exclusion and taken out by the police. The matter comes back to court. The police speak to the affected family member and she doesn't want the exclusion to be there. She doesn't want, and sometimes she'll apply herself to have the order revoked. The police in that situation would do a risk assessment, but if they still wanted the order in place, the Act only permits the court to order what's called a 1 and 2 order. That is an order that the respondent's not to commit family violence, and also an order that they are not to damage property, intentionally damage property or threaten to do so. So orders can be crafted according to the needs of the situation, and there can be some conditions in place less than a full order. Commonly in the cycle of family violence, where there might be family violence, separation, remorse, forgiveness, and the parties back together again, you may have a cycle where they're in and out of court over a number of years, having an order in place, then coming back and seeking the revocation of the order, or the order expires, and then they're back before the court again when there's some further eruption in the relationship.
Can I just add something? Sorry. Thanks. I'm not really game too surrounded by all these legal people, but I'm just going to say it anyway. I think intervention orders are an important tool, but I think it's also worth mentioning the fact that sometimes intervention orders can actually increase danger for women and children. So I think that's sort of something that we need to be mindful of, because often I hear things like, oh, she won't take out an intervention order. I think women are often very aware of the safety and risk factors in their relationships with perpetrators. So C&V would be better able to talk to that than me, but I just thought that was worth mentioning. Quite often the system becoming involved in a woman's life can really escalate the risk. So that's why it's really important that we always gain the woman's insight in relation to the perpetrator's behaviour, because it's a perpetrator's behaviour that we're going to be focusing on, because that's where the risk is. So, but it's gaining the woman's information on what she knows about the perpetrator, because she knows him best, what he's done in the past, what he's likely to do. And very common things that we hear are, he's told me if I ever go to the police, he will kill me. If I take out an intervention order, he will kill me. So women are thinking very clearly around what is going to be the best for themselves and the children in relation to managing risk, and always going down the intervention order track is not going to work for them. So that's why in family violence responses, we go through tailored safety plans, and that's in relation to what is a support service that is available 24/7 if women are seeking support and not wanting to involve the police because of what they feel may happen in their knowledge of their ex-partner or partner's behaviour in relation to their safety, because that's what we're focusing on, is a perpetrator behaviour. So we have systems such as Safe Steps, which is a 24-hour service system where women can call to get assistance if they're not wanting police or system involvement at that particular point. And if we use Fiona as an example, the police response closed her down completely
with her initial disclosure. So a lot of women don't have trust in the service system. So as we know, family violence is a very complex issue, and we know from research it can take up to 8 times for a woman to leave an abusive partner, and there's multiple reasons for that. And one of those things are that women can be very committed to the relationship. They're wanting the abuse, they're wanting the behaviour to stop. They're not necessarily wanting the relationship to end. They may want the family to stay together. So the focus is on the man's behaviour, and that's why we have programs very clearly focusing on behaviour. You know, men that commit violence are men that we all know at various times. They're, you know, family members, they're people in the community, and it's around their behaviour. We're not creating men that are perpetrating violence as others. They're men that are all within our community, and that's their behaviour that we focus on. So I think it's always helpful to stop and reflect how easy it is to focus on why doesn't she just leave? It's not good for the kids, just pack up and go. But it's a very complex issue. Up until recently, resources have been very, very limited, and I think through this case scenario it's clearly identified Fiona had no access to resources. She had limited income, part-time. She left for a week, she ran out of money and she returned home. That's a very common scenario. So it's a complex issue. So, you know, there is no simplistic answer. There's no broad sweeping answer. And that's why assessments need to be very focused on every individual situation, using evidence-based risk factors to focus on perpetrator behaviour, to work towards safety of women and children, and using an integrated broad system response.
I just want to add quickly that the courts are very sensitive to the need to hear the voice of victims and not to take a paternalistic approach and override the wishes of the victim. You have the tension between the need to restrain and prevent family violence and the wishes of the affected family member, the victim, which may be, from the court's point of view, leading into a situation there where there's a potential for further family violence. We try and we give the victim a voice when they come along to court. We also have an avenue whereby the police throughout our region on a return date will provide an up-to-date affidavit to us. Typically the police court liaison officer in family violence will provide an affidavit. They'll have spoken to the affected family member, they'll have ascertained her wishes, they'll have set out risk factors, any developments. We'll have an up-to-date affidavit which will set out those issues, which will make it easier for us to make a decision and to give proper weight and voice to for the victim.
We have a rural question. Given that the family live on a rural property and there's a possibility that there are firearms, how can the police or the courts manage this and remove the weapons?
We have power on the interim order and the final order to revoke or suspend firearms licences and require the firearms to be delivered up to the police. And if there are firearms involved, then typically the police will tell us that and ask for that to be included in any application that they make to the court. And we would commonly make such an order. And with a final order, if a respondent wishes to have a firearms licence, then they need to apply to the court to be declared a non-prohibited person, and police would review such an application. They're entitled to be heard on it. Sometimes they will agree that they should be a non-prohibited person. For example, if the firearms used on a farm to shoot vermin and there's no risk factors, then typically the police won't oppose it. But there is a strict legal process that will restrict access to firearms for perpetrators.
This is a question for the panel. How can, from your perspective, how can family violence be managed from a more therapeutic perspective within the family violence system? What are the changes currently afoot or the changes that are needed to provide more therapeutic support for families experiencing violence?
I've been practicing here for the last few years. I've seen a transition in our decision makers, the magistrates in the region, and from my perspective, I think the magistrates here are taking quite a therapeutic approach to how they deal with people appearing as victims and perpetrators of family violence in our court system. That generally both parties are treated with respect. They both are heard, and it certainly isn't. It isn't as authoritarian as it once was, maybe. I think there's quite a therapeutic approach to both parties.
Surprise, surprise, but we come back to resources and funding. But my frustration, and it's been for decades now, is that there is reduced interaction between the family violence court of the Magistrates Court and the work of the Federal Circuit Court or the Family Court of Australia. And I know it's a matter of funding, but there should be an allocation. There are plenty of lawyers out there. Not enough lawyers are getting jobs, and lawyers can be particularly trained, but to be funded for the children to have an independent lawyer on the first return date when Fiona and Michael go to court, and you know that there are orders concerning their children, that lawyer gets involved and he takes or helps take the burden off the whole family, but in particular children, and become a bit of an official investigator to see where we go next. Because this week we've had a matter in my law firm where it will take, there's an intervention order. The father can't see his children. He's trying to negotiate. He's offered supervision. It will take 6 weeks for the next court event for anything to be done. And in those 6 weeks, enormous harm can be done. The headmaster's ringing up with a little girl in prep saying, "What's happened to Daddy?" And there's no official way that we can intervene and speed up the process.
I'll just build on that a little bit, just to highlight the lack of resources in accessing family court and how it doesn't sit in the country areas on a very regular basis. So these processes are very, very drawn out. So it is around resources, but also taking into consideration the significant impacts and differences that need to be considered in rural, regional and remote locations. It's not one size fits all, so in taking into consideration moving forward to provide appropriate resources, including therapeutic responses that allow recovery for women and children from their experience of family violence, that the resources are tailored to suit the geographical locations, and things like that need to be considered, and a very clear consultation with the sector to see what has worked in the past and what does the sector and the community members think is going to work for their own community. And can I just talk just a little bit briefly? We've talked about the system intervening in family violence. Planning to leave and leaving a family violence situation is the most dangerous time, and that's also something that needs to be considered. So when there's just a very simplistic approach, we'll just go and get an intervention order and leave him, shouldn't stay because it's not good for the kids. The woman knows very well that that's the most dangerous time. So planning to leave and leaving and ending a relationship where the perpetrator, your partner, has been violent is the most dangerous time. So those things need to be considered in all aspects of the work that we do. Yep.
Ours is also a resource issue in relation to the courts. So I'd like a lot of what's available in the headquarter courts to be available in the other courts as well, such as Maryborough. So ideally, we could be funded to have an applicant and respondent support worker that would come out on circuit with the magistrate each time we sit in these towns to provide support for people. Also, having sat as a family violence court magistrate, getting perpetrators into men's behavioural change programs and in WA into a residential men's behavioural change program at Breathing Space. I think you see the value of these programs and being able to operate a designated family violence list in each of the locations with the support services in place, the ability to get perpetrators into programs and addressing their issues, and to support victims through the process as well, through appropriate referrals. I think those resources are needed in each of the satellite courts to Bendigo.
Ladies and gentlemen, if you could join me in thanking all of our panellists for their assistance today. It's been really interesting and invaluable.